Hey everyone, welcome to the Be Insightful in Technology podcast. I'm your host, Shikirah Johnson, also known as Shy, and I am here with Byron, my co-host, and we'll be interviewing someone with a different skill set that we've had on the podcast. So I do want to, introduce you guys to him and hopefully that you guys see a new perspective of what's available in the tech industry. So, Robert, will you tell us like who you are and what do you do? And also how can people find you as well if you have any social medias?
Absolutely. Thanks, Shai, for having me, and thanks to be here with you, Byron. I am a patent attorney, and I specialize in software patents. What that means is I generally work with growing tech companies, companies that are developing new kinds of software, often new types of AI, and I obtain legal protection for them in the form of patents. So if they developed a new algorithm, a software that does something new, the patent protects them against that being copied by a competitor without their permission. And you can also license or sell a patent. So if you obtain a patent, you can charge someone. A license is basically rent for permission to use that technology. And if your company ends up getting sold, the patent is an asset that has value, that adds to the value of your company when you sell it. So I love working with tech entrepreneurs. I'm often working with companies from before they've even been founded, when the founders just first have their idea, all the way through the development of their product, sale of the product, growth of the company, and eventually, often when the company goes public or gets acquired, I work with the whole company through that entire life cycle.
Ooh. So, how did you get started into patent law for one, especially focused on like IT technical patent?
Yeah, so I started programming when I was a kid, which was back early 80s, early 1980s. I just loved working with computers in that way. So it was a hobby of mine all through my early years. Uh, and eventually I went through. I decided I really didn't want to be into the weeds of programming, but I wanted to keep my feet in the world of technology. And I loved writing. I really liked philosophy and political science. I thought law would be a good place to go into. I knew a few people who were lawyers, not too many though, actually. Ended up going to law school. And at just around the time when I was graduating, software had become patentable. You know, traditionally, patents apply to machines like car engines or mouse traps or all those kinds of physical things. And software had not really been widely patentable. But around the time I graduated law school, mid to late 1990s, the law had developed, was trying to keep up with developments in technology, and companies were starting to get software patents in large numbers. I went into patent law at that time, worked for a couple of big law firms, and then I went out on my own, eventually co-founded Blue Shift IP with another patent lawyer. But I've been working as a software patent attorney for over 25 years, and it's really helped me to combine all of my skills and interests together, which is in staying up to date on the latest technology, working with people who are developing the latest technology, and also helping them strategize, helping them build companies. I have to learn about new technologies all the time, learn how to explain them to a patent examiner, to investors, to other lawyers. All those, it puts all those skills together in one place, and that's what I really enjoy about.
Oh, I honestly, before talking with you, I didn't really know that this was a thing. It's like when you watch all the documentaries on how technology came to be, you see they talk about patents a lot. And it's just like, all right, they've patented this new technology. What does that even look like? That process blew my mind.
Yeah.
Right, yeah.
So what I know you talked about, being able to combine your different skill sets and basically putting them all into one. What is like one of your favorite things now, or at least one of the things that you were able to go through and patent, like work with a company to patent or individual? Like what is your favorite?
It's hard to say. I don't really have a single favorite, but what I enjoy doing is working closely with, as I said, whether it's the founders or inventors at a bigger company, and really diving deep into what problem was it that they were trying to solve. I'll give an example. I had a client for many, many years that was doing medical speech recognition software. They were developing new kinds of software for medical speech recognition. And so, doctors are notorious for having horrible handwriting when they write prescriptions. And we laugh about it, but it's actually quite a serious problem, because if someone, the pharmacist, reads the doctor's handwriting incorrectly and gives you the wrong drug, that can have really serious consequences. And so, uh, speech recognition software can take what the doctor says when he or she is prescribing something to you, and try its best to uh, understand that accurately. But that's a really hard problem as well, because medical terminology is really complicated. There's certain terms that are very similar to each other, but not exactly the same. And so this client of mine, that's one of the things early on that they had to work on, was how to create software that could recognize medical terms really accurately, and then do things like make sure there was always a human doctor or healthcare professional who would review what the software did. We can't rely in the context like that on the software doing everything and then just uh, producing the right result without human review. I really enjoyed working with them, in part because they were doing something that had real benefit to people's lives and health. Another example of software they developed was software that could catch um, contraindications. So if a doctor prescribed a drug to you that you were allergic to, it can look at your medical history and your medical records and know that you're allergic to that drug, and tell the doctor, hey, wait a second, maybe you shouldn't prescribe that drug. It got way more complicated, much more complex and advanced than that over the years. But, my role in that situation is to understand what the new invention is, and then be able to explain how it works, what it does, and what its benefits are in a patent. And, I don't know if you of your listeners have seen patents, but they're long documents, and they have to explain in fairly plain English what a new invention is, how it works, how it's different from everything that came before, and what its benefits are. And that can be, quite challenging. We submit the patent application to the patent office, which is a government agency, and then someone a patent examiner, gets assigned to review the patent application, and they have to then try to understand it and accept or reject it. Usually they reject it, like when you would submit an insurance claim. Sometimes you get rejected, and then you have to go back and argue your case. The same thing with a patent application. The patent examiner might say, oh, this new invention for a new type of software, I think it's not new. I think there was another type of software in the patent, and we have to go back and explain or argue why we think the examiner is wrong. And so I really enjoy doing all of that. It is quite a long, detailed, time-consuming process. To obtain a patent can take anywhere from a year to 3, 4, 5 years, part because the patent office is slow, part because it just involves a lot of work. But it's really satisfying for me, and it helps my clients, particularly smaller companies, to protect themselves, usually against much larger competitors.
Can I ask what it's been for your experience? What was the shortest time that a patent was accepted versus like your longest time that a patent
Yeah,
was approved?
you can now speed up the process at the patent office in several different ways. One of them is you can just pay the patent office an additional fee, and they'll speed up the processing for you. There's a bunch of other bases. If you have technology that there's this green acceleration program, or if you have a technology that improves energy efficiency, there's a whole bunch of programs that they'll examine more quickly. But I've gotten some patents granted in, I think, around 8 or 9 months would be the fastest under those accelerated programs. And did you ask what was the longest?
Yes.
Yeah.
I think I had one that went maybe like 14 years.
Oh my goodness.
Because we kept getting rejected. We went back and forth. You can, if you're in court, you've heard of appeals where you lose a court case and you appeal to a higher court. Well, you can do the same thing essentially within the patent office. You appeal within the patent. I had a case where we lost, we appealed, we lost on appeal, we came back down, we got rejected by the patent examiner a few more times. We appealed again. We partially won on appeal. We came back. That kept going on and on. Eventually, the client got the patent granted. That was the longest. Maybe, yeah, probably 14 or 15 years.
I know they
And
must have been
how do you
finally
keep
excited.
like how do you keep like the momentum in on a case like that? Like how do you, wake up every day like, oh, I hope, we're one step closer to where we want to be. And 15 years later, it's.
Yeah, you don't really keep momentum in that situation. It certainly is challenging. I might have a few hundred patent applications in process at the patent office at any given time. So sometimes, I'll get something from the patent office, a rejection from a patent examiner, and I'll look at it, and it'll be on a patent application that I haven't worked on for a year or two. So I have to read it, and I have to remind myself what it's all about, what that invention was, and get my head back in that space. But it's one of the benefits of accelerating examination is that things happen much more quickly in the span of a month or two. You'll submit something, hear back from the examiner, and you can go back and forth, keep the momentum going, and it's easier for everyone involved to just remember what's going on and keep their head in the game in that type of process.
Got you.
So do you typically work on more than one patent with a founder or whoever's creating?
Yeah, it really depends on a few things. It depends on how much it is that they have invented. And so, sometimes let's say a startup company, they've developed something and they have like one core idea that's really new, in which case it sometimes is both possible and beneficial to start by filing one patent. Sometimes that's not the case. Sometimes a new company may have a few different technologies that are maybe closely related to each other. They're all related to autonomous cars, but they're addressing different problems. In which case, if they want protection for all of those, it's necessary to file several patent applications. But it's going to depend on other things too. It's just going to depend on the budget that the client has. It's going to depend on how important patents are to them. It's going to depend on who their competitors are and how much competition they're facing. All those things will factor into how many patents they file and when, to do several all at once in the beginning rather than, let's say, stage them out over time.
Oh, wow. So I want to get
Now,
into a couple of, oh, go ahead, Byron.
I was just going to ask a quick question on this. So in regards to like you said, having a patent for different scenarios for, a specific product or an idea, is there a way where clients, or do you have to set expectations for them in regards to like product enhancement? Because to me, someone with no experience in this, I would think that there's no real way to foolproof like an invention with just one patent, as you described. So it's like if they make enhancements to the product over time, do those patents change over time?
It's a great question. It's a very legitimate concern. And so you're absolutely right. It can be difficult to obtain a patent that really protects everything the company is doing for exactly the two reasons you mentioned. One is that the company itself may make changes or improvements to their own invention over time. And the second reason is that competitors may address the same problem with different types of solutions. So, a car engine, there's, let's say, even within the realm of combustion engines that burn gasoline, there's still quite a lot of variation in how they work. So if you got a patent on one type of combustion engine, it wouldn't necessarily block anyone else from making a combustion engine if it was of a different type. So you can't protect yourself perfectly against all of those, but a big part of what I do and what I have experience doing is I work with the company and the inventors, identify what is it that's new about what you've come up with, and then we work together to brainstorm. What are all the other ways we can think of that this invention could be built, could work? What if it's a physical invention? What are the different types of materials you could use? What are the different components that could be substituted in to perform the same function in a different way? If in software, what are the different types of algorithms or steps or types of code you might use? So that we then write a patent that covers as much of those variations as possible from the beginning to protect the company against as many of those as we can. I'll tell you, it's never possible to do it perfectly just because of the limits of time and because the next day someone else may come up with another idea, right? That's the nature of innovation. But we do our best to make each patent be as extensive as possible to provide as much coverage and protection as we can. Does that answer the question?
Yes, sir.
Yeah.
So my question on that as well. So have you ever had people come to you for a patent idea, but it was already in the works, but you saw a piece of their technology that wasn't patented and can be? So they initially came to you for one thing, but there's actually another part of their invention that is eligible.
Yeah, absolutely. It happens quite often. I mean, I'll say it happens quite often that people come to me and I tell them that what they've come up with can't be patented. Sometimes people have a great business idea for a business that could be really successful, but they don't have anything that's patentable because for something to be patentable, it has to be technologically new. And there's lots of new businesses that are commercially new. There might be a new business model, new way of pricing things, new way of distributing products more efficiently that doesn't really involve any new technology. And in those cases, I tell people, looks like you've got a great business idea. You could probably be very successful, but it doesn't mean that you can get something patented. Sometimes what happens is exactly what you said. They think that there's something that's really new. I will advise them either just based on my general experience with patents or by doing additional research into what's been patented already. I'll come back to them and I'll say, well, you thought this whole thing could be patented, but only a small piece of it could be patented, but that might still be valuable. Or as you said, there's some other angle on your invention, some other way of thinking about it that could be patented, and that would still be valuable to obtain a patent on. So yeah, very often that happens early in the process.
Okay.
I had another question in regards to patents, because this is opening up more, I guess, possibilities for me of like how I trying to imagine this working. Have you ever run into any instances or like fields per se where something can't be patented because there's like a restriction set by the patent office? Like, are there any like regulations in place that, you know, certain things are off limits, so to speak?
That's a great question. In fact, the answer is yes. And those regulations and guidelines have changed over time. So, for example, there was a court case back in 1998 that basically said certain types of business methods could be patented, meaning methods for, let's say, calculating someone's salary in a new way, using a new kind of formula or algorithm. No one's been able to ever clearly define what's meant by a business method, because you could say, I mean, any method carried out by a business, even using technology, is a business method. If it helps the business make money, isn't that a business method? But generally, business methods involve calculating financial information, helping people engage in forming contracts or business relations. So for a while, it was possible to get patents on business methods fairly broadly. And then as a result of some court decisions and changes in the patent statute, which is written by Congress, changes in policies of the patent office, it is now much, much more difficult to get patents on business methods. It's not impossible, but when someone comes to me with a new business method, unless they have also developed some fairly sophisticated type of software or other technology that makes the business method possible, I typically tell them it's not worth trying to obtain a patent on that because it's going to be so difficult to get it that it's often not worth it. So other things like methods of teaching, educators can be really innovative in coming up with new teaching methods. But unless those are tied to some kind of new software or machinery or other technology, those are usually not patentable at the moment.
Okay.
Byron, I want you to go through Byron has some really good questions that I really want to see if we talk about because it tailors to like what do you feel like could make the industry better as a whole, and we can focus on your experience as like a patent lawyer. So if you don't mind, can you run through like what a patent is again for the audience?
Yeah, a patent is a form of legal protection for an invention. So like I said, for me, it's usually a new type of software. It could be pure software. I mentioned speech recognition software. It could be software that works with hardware, like software that controls a robot, or software that steers a car or detects obstacles. Our cars now have tons of software in them for controlling the brakes on the car, or for telling you when there's the lane assist technology. So there's all kinds of software that could be patented, or more traditionally, mechanical devices, electrical devices. You can get patents on new kinds of chemicals. New drugs are usually patented. And so when someone invents a new thing of any of those kinds, if it is new and different from anything that existed before, and it has performs some useful function, has some benefits, you submit a description of the invention to the patent office, gets reviewed, and if the patent office agrees that that invention is new enough and useful, the inventors or the inventor's company or university gets granted a patent. And what that does is gives that patent owner the ability to stop anyone else from selling or even using the invention without the patent owner's permission. So when I talk about a patent protecting the owner, what it really means is if I invent a new type of mousetrap and get a patent on the mousetrap, and I see someone else selling that mousetrap at the hardware store, I can go to court, show evidence of my patent and what it covers, and show them, look, this mousetrap is being sold by someone else. I didn't give them permission to do it. The court can issue an order called an injunction to stop selling, and I can get actual what are called damages, meaning money based on what they've earned for selling that mousetrap without my permission. Now, in practice, the vast majority of patents don't end up in court. Most of my clients don't ever sue anyone for infringement. Just the existence of the patent usually deters other people from selling infringing products. And then what happens is if a client of mine sees someone else selling what they've patented without their permission, we'll usually approach that other company, let them know, and then often it's possible to enter into an agreement with each other where the other company will either stop selling what they're selling or agree to pay the patent owner a fee in order to get permission to sell the patented product. And that's what's called a license. That fee for using a patented invention is called a license, and the payments are royalties. So that's basically what a patent is. It's also, as I said, it is an asset. Just like cash is an asset, or real estate is an asset, or machinery are assets. And if you had a company, let's say, that had a manufacturing plant and you sold the company, that manufacturing plant would be given some value, $100 million. It's an asset that has value. Well, patents have value also. So many of my clients acquire patents in part to increase the value of their company, so that if they then get sold or acquired by a bigger company, they'll get a larger amount when they're sold. Same thing if they go public through an IPO. The existence of the patents adds value to the company. So these are all ways in which patents are used outside of court, which is, it's a kind of a misconception that people get patents in order to sue people for infringement. That actually happens very infrequently. Most of the time that can be avoided, and it's used for these other purposes.
Quick question. Can patents be transferred? So like when a company gets bought, does the patent get transferred to the new owner, or can you keep it?
Yeah, that's a great question. It is an asset that can be transferred fairly freely according to what the owner wants to do. Usually when the whole company is sold, the patents are sold as part of that sale, but they don't have to be. They're fairly independent assets. It's interesting, trademarks, and I'm not a trademark expert, but a trademark like our name, Blue Shift IP, or Coca-Cola, those can't be transferred independently because they're considered to be tied more closely to the company's product. So, Coca-Cola can't just sell the Coca-Cola trademark to General Motors to start using if they don't also sell the business of Coca-Cola, the drink, to General Motors. But a patent can be really sold on its own, independently of anything else. So it's a great question, and most people aren't aware.
All right, so yeah, I'm really interested in this. Byron, you got to get to your questions.
Yeah. So I think he's already given an example of a patent, but it wasn't specifically like an AI patent. So we're gonna tilt more towards AI now.
Yeah.
So let's see my first question. All right. So how is patent law adapting to the challenges posed by AI inventions? And I want to say that while I was on LinkedIn this morning, while I was in my hotel room, I came across some of your articles on AI. I think your latest one was whether or not AI should be considered an inventor.
Right.
So yeah, I would love for you to cover some of this in your experience.
Yeah. So it's interesting. I have been working on AI related patents for a really, really long time, also writing about them, teaching about them. I wrote a book back in 2009, which is ancient history in computer time, which was about AI generated inventions and the way in which people were using AI to help create new inventions. And the book then explored all the implications of that for the patent system. And in all this time, that I've been talking about this topic and working with clients to obtain patents related to AI, the first thing people always ask is, oh, can the AI system be named as an inventor? If an AI system creates a design for a drug, should the AI be named as an inventor? In fact, this question has been examined by the U.S. Patent Office, by U.S. courts, by some courts in other countries in recent years. So far, every patent office and every court that's addressed it has answered no, that an AI system can't be named as an inventor. I think that's the right answer. Actually, I literally posted an article on LinkedIn this morning about that and why I think that's correct. I don't go into detail, but if you think about why do we have a patent system in the first place? Sometimes people assume it's sort of to reward people for inventing. You put in a lot of work to come up with this a new drug, create a new drug. Uh, you should be rewarded for that financially, and the patent helps you generate money from the drug. So that's what it. But really, but reward is not what the purpose of the patent system is. It's actually to provide people with a motivation to invent new things and to, what we say, disclose those inventions to the public. Because a patent is a document that's available to the public. So what does that mean? It means, when you've got a person who's a brilliant inventor, and they wake up in the morning and they decide, how should I spend my day? Should I try to work on inventing a new drug? The idea is this: if they know that when they invent the drug and they put 5 years of their life into coming up with that drug, and they get investors who put tens of millions of dollars into the drug development, if they know that when that's all done, they can protect themselves against other companies knocking them off for free, they'll be more likely to invest all of that time and effort and money into inventing something new, because they'll have some protection that will make it more likely they'll earn back their time and money. On the flip side, you could say, if there were no patent protection available, why would someone put their time and effort, particularly in situations where it costs a lot of money and investment, why would they put all of that in if they know that as soon as they put the product out into the public, anyone else can see it and then start knocking them off for free? So that's the reason. People respond to these types of incentives that the patent system gives. And the argument I've been making, you can see it in the article, quite a few I've actually published on LinkedIn recently. AI systems don't respond to incentives. AI systems don't get motivated to do what they do by the promise of a patent or of earning money from a patent. If you ask ChatGPT, help me brainstorm about something, it just responds to you. It won't not respond if it thinks it's not going to get paid. I mean, it may sound bizarre or strange, but there's no reason to give an AI system listed as an inventor on a patent, or to give it patent rights. It just doesn't respond to the incentives of the patent system. So that's the whole reason we have a patent system. That's why. So I actually think this issue of whether we should name AI as an inventor, although it's the first thing everyone thinks of, maybe because of science fiction and so forth, that it's not the most important. It's not the most important issue that AI raises for the patent system. I mean, I can talk very, very briefly about one issue that it does raise, which is, maybe you're familiar. People have been observing a lot ever since ChatGPT came around, which isn't particularly good at inventing, but it's good at doing things like writing or brainstorming or coming up with ideas or summarizing information. It's good at a lot of stuff. People have been observing that if you use ChatGPT to write, it can essentially boost your writing skill, right? It can enable you to write things more quickly, and especially if you're not that good as a writer, if you're at the low end of the writing skill spectrum, it can make you be. When I say make you be, I mean enable you to produce writing that's a lot better than you could on your own if you didn't have it, right? So that's like a boost. It's like a writing skill booster. And the same is true for AI that's used in the process of inventing. Okay, inventors use things to help them come up with, like I said, new designs for drugs. There's software that can basically simulate how new chemical structures that could be used for drugs, how those might behave in the real world, and evaluate them and enable people to test out a huge number of possible drug designs without ever building them in a lab, much more quickly and easily and less expensively than would be possible before. It's like simulating a large number of experiments. So in that way, a human drug inventor can use that type of technology to boost their ability to try out new drug designs and evaluate them much more quickly, easily, and less expensively than would have been possible before if they had to build it, create everything in the lab. So the big issue that raises is if it becomes way more easy to invent new things, should those new things be patentable anymore? If it becomes possible for a larger range of people to invent things like drugs or mechanical devices or car engines or software, if it becomes easier, why do we need patents to encourage people to invent new things if basically, I don't want to say anyone can do it? Do you see what I'm saying?
Yeah.
That's really the bigger issue. And if it becomes easier, should the bar be raised higher to get a patent? Should you have to show that what you came up with is sort of more inventive in order to be entitled to getting a patent than you would have before the existence of AI?
If you like what you're listening to, be sure to leave a rating and subscribe to the podcast so you don't miss part 2 of Robert Plotkin's episode. Thank you for tuning in to gain knowledge, wisdom, and understanding to be insightful in technology.